Hello, and welcome to Gateway to Privacy, a podcast from global law firm K&L Gates, where we discuss the latest developments and best practices in today's data protection, privacy, and security industry. We hope you enjoy this discussion. Please reach out to suggest topics or guests, or with questions about data privacy law.
Hello, and welcome back to Gateway to Privacy, presented by K&L Gates. I'm one of your hosts, Jake Bernstein. I'm a partner at the K&L Gates Seattle office, and my practice focuses almost entirely on cybersecurity and privacy. With me today is Eric Vicente Flores, who is an associate in our Seattle office, and he is CIP US certified. Welcome to the show, Eric.
Thanks, Jake. Good to be with you today.
So today, we're going to have a high-level discussion on the Colorado Privacy Act, although I think we're actually going to get pretty detailed as well, alongside the accompanying rules and regulations. These are going to go into effect on July 1st, and it might seem a little bit routine now. This is the third state privacy law in the U.S., and it's the second new law to go into effect in 2023, unless you count the CPRA amendments as a new law, but I guess that's semantics. So, Eric, what can we expect from today's podcast?
Well, Jake, there's a lot to cover. The statute is 33 pages long, and the rules are a little bit over 40 pages long. So we won't be able to cover everything, of course, but the good thing is that the regulations that were published last month, they're the final set of regulations. So we have about 2 months to digest these rules and get ready for when the law goes into effect on July 1st, like you mentioned. So what we'll do is discuss the requirements of the law independently so that listeners who might be subject to, the Colorado law understand the requirements, and then briefly touch on how those requirements may compare to the CCPA, because obviously there's already some businesses that have implemented processes to comply with the CCPA.
That's great. So let's start out by talking about the scope of the law. Who does this law apply to?
So Colorado law, it applies to any legal entity that conducts business in Colorado, and it's split off into two. So the scope applies to any business that controls or processes the personal data of 100,000 Colorado residents, or that derives revenue and receives a discount on the price of goods and services from the sale of consumer data, and then processes 25,000 consumers' data.
Got it. So, if you're a business and you process the personal information of 100,000 consumer residents, then it applies. And I think we should be clear here, and we will talk about this, but, the definition of personal information is pretty broad, and it is more expansive than I think a lot of people think. So it's not even that hard to hit 100,000. Now, it turns out in Colorado, if you're making a profit from personal data, then the threshold drops down to 25,000, which really is a fairly small number once we kind of start discussing the full scope of the definition. So why don't you tell us a little bit about that, and maybe also briefly hit on what exactly this 25,000 consumer threshold is.
So that threshold, again, applies to any business that derives any sort of revenue from personal information. So theoretically speaking, we're going to be seeing maybe some smaller businesses and mid-tier businesses that are going to fall within the scope of this statute that we might not see maybe under the CCPA, or even Virginia, for example, who that law has a specific percent of gross revenue that must be derived from the sale of personal information. And here, again, it's any sort of profits. Now, how this is going to be enforced remains to be seen, seeing as the law hasn't gone into effect.
Got it. So it's pretty clear that, this law is going to end up applying to probably a wider scope of businesses than people realize, which is good to know. So let's talk now about the type of data that is considered personal information. Does it really differ significantly from other statutes, particularly CCPA?
Well, as you mentioned, it is quite a broad definition, and the law itself defines personal data as information that's linked or can be reasonably linkable to an identified or identifiable individual. And that is quite broad. when you consider everything that may encapsulate, you're seeing something that could potentially implicate a lot of categories of data that you might not think about when you think of, data privacy.
That's true. And I mean, I think it really has been eye-opening for a great number of businesses, particularly within the marketing departments, right? To find out the kinds of information that can be considered personal information under these laws. And this goes to kind of my crusade against the phrase PII, personally identifiable information. That phrase, as used historically, is very limiting compared to the modern definition of personal information. The modern definition includes IP address, even a device's MAC address, even, geolocation data is considered personal information. It's just a lot broader than it used to be. Not only that, but they're starting to recognize and define sensitive data categories as well. So maybe tell us a bit about that and what is considered sensitive data under the Colorado law.
So this is a category of personal information that we've seen defined by other statutes. Colorado defines sensitive data as any data that reveals race, ethnic origin, religious beliefs, mental, physical conditions, citizenship status, and genetic or biometric data that can be used to identify an individual, and also physical and health conditions. So this is something that we've seen before defined in California and also Virginia. But what's unique about Colorado is that the rules have introduced what they call sensitive data inferences. And in the most simple terms that I can put this, sensitive data inferences are inferences that you can make from personal information that can reveal or essentially lead a business to infer sensitive data. And the regulations actually provide an example where, let's say that you are collecting a consumer's precise geolocation, and that's just considered personal information. Well, if that precise geolocation is used to infer whether an individual visited a mosque, for example, and you're using that to infer their religious beliefs, then that geolocation data is now considered sensitive information.
Interesting. So that really opens up a lot of possibilities. I mean, there's the old saying, the store might have more information about you than you realize because it knows all the things that you've purchased. And I think that is really what this sensitive data inference concept is getting at. So now the use of sensitive data does come along with a number of additional requirements and duties, which we'll discuss in a bit. But let's first just kind of hit on the overall concept of the duties that these laws create that businesses must comply with. So they have to provide consumers with a valid notice, and that's usually the privacy policy or privacy notice. But they also have to abide by a concept called data minimization. They need to figure out data retention and then also conduct data protection assessments. So the privacy notices, even though they are becoming increasingly important, because they have to not just disclose how your business processes information, and that can be challenging enough. But these days, there's an increasing desire from legislatures and enforcement agencies to make them easy to read, because the argument would be, if you keep your privacy notice in legalese, then it's not really understandable by people who need to read it. Therefore, are you actually being transparent? Has notice actually been provided? So what does Colorado's law require from a business's privacy notice? How is it? And if it's different, let us know how it's different.
Well, like you mentioned, there's this sort of tension where a business has to accurately disclose what it does in a privacy notice, but then it has to be in very simple terms for individuals to understand it. And as a quick overview, Colorado requires that a privacy notice includes a description of the controller's online and offline data processing, and it must give consumers a meaningful understanding of how each category of that personal data is used. So to do that, the statute and the regulations sort of provide a laundry list of everything that must be included in the privacy notice. And first off, we want to include a disclosure of the categories of the personal data that's going to be processed, and whether it includes the data of children or other sensitive data. What's nice is that, unlike the CCPA, Colorado asks that you sufficiently describe the data being used without prescribing an exact category like the CCPA does. I know that that's been the bane of many businesses. So, for example, Colorado just mentions that you can disclose contact information from cookies, payment information as potential categories that you can name. And as a reminder, the CCPA actually provides the exact names that need to be disclosed in a privacy notice. You'll also need to disclose how data is used, the purpose for being collected, whether the data is sold or used, the categories of personal data that are sold and shared with third parties, what's being used to profile an individual, the categories of third parties that the data is being sold and shared with. So, for example, these categories can include analytics companies, data brokers, third-party advertisers, et cetera, et cetera. Also a list of the data that's being used for like profiling reasons, and obviously a list of available data rights. This is something that we've seen all the other data privacy laws include, along with a detail of how a consumer can appeal a business's response to a consumer request. And that's something that's new. And then the business's contact information, the date that the privacy notice was last updated, and then certain retention and deletion timelines with respect to sensitive data, if the business is going to be collecting those. But something that businesses should keep in mind is that if there's any material changes to a privacy notice, then the consumer has to be notified of those material changes. So businesses should be careful when they're making changes to a privacy policy. Businesses should be careful of the changes that they're making to these privacy policies, and making sure that they're notifying the consumers, hey, there's been a change. Here's our updated policy. And the statute itself it provides a lot of information on this. A material change includes any change to the categories of personal information being processed, the processing purpose, who you're sharing the information with, or if you're altering the process that you have in place to process an individual's data requests. So essentially, if you're making a material change to a privacy policy, make sure that you're communicating that to anybody that has had access to it prior to that date.
Yeah, one, that's a long list. It really is. And I think what is probably going to be challenging for a lot of clients and businesses out there is that even though that's pretty close to CCPA and pretty close to Virginia's CDPA, there's always these little detail differences that I'm noticing. And I think it's going to make it challenging to have a one-size-fits-all privacy notice or privacy policy, even though that's probably the most reasonable method of disclosing that. I think it begins to dilute the utility of a privacy notice if you have 17 different privacy notices. So it's going to be an interesting challenge for us and for clients moving forward. I think we can talk a little bit about this idea that a consumer can appeal a business's decision on a data request. So what does that mean? Because that isn't something that I'm aware of that exists under CCPA.
No, and you're right, Jake. So essentially, Colorado included this additional right for consumers where if they submit a data request to a business and the business, let's say, denies that request, the individual can then appeal that, which is something that's absolutely new. And that decision and process, as it's being carried out by the business, must be disclosed on the privacy notice and also described so that obviously the individual understands what the appeals process is like, and also that they have that right.
One of the other things that's changing these days is, it used to be that you could have, 5 or 6 bullets describing essentially every potential purpose for personal information gathering and processing. And let's be honest, those are not always the most helpful. Certainly when, as consumers, if you run across those, you wonder what they mean. Now, have these laws begun to crack down a bit on that practice? Are we starting to see a move toward more specific a requirement for more specific disclosure about, purposes and for purposes for collection and processing.
Yeah, absolutely. So as we mentioned earlier, when you have a privacy notice, you want to be as specific as possible about what a purpose might be for you, for the business collecting that information. So Colorado actually requires that instead of including just very sort of abstract purposes or something that potentially has a very broad scope, it has to be quite narrow and actually explain to the individual reading the privacy notice, hey, this is why we're collecting the information and this is what it's being used for. And this also avoids businesses sort of being forward thinking. I know that sometimes, clients or businesses might say, well, we could theoretically see our marketing team having a new purpose or for this piece of data that we're collecting now that we just don't know how we're going to use it yet. Well, when and if that time comes where that new purpose comes in for that piece of data that you've already collected, you need to update your privacy notice and let the consumer know with specificity that that information is going to be used for that new purpose.
Okay, so this is common. I think this is starting to expand around the other states. We have a number of kind of other topics to get to, though we are starting to run out of time. I think consent is worth talking about at some point. Consumer rights as well. I'm just going to really quick. Consumer rights, Colorado doesn't have anything that is totally new here. It's pretty similar to California, similar to opt-out rights. What I want to skip to is the duties regarding sensitive data and data protection assessments, because both of those are either new or CCPA doesn't have them, or if it does, they're just part of the CPRA, and we're still kind of waiting to learn more about that. So let's go ahead and skip down to duties regarding sensitive data. And we did briefly talk about it. So first, and this does go to consent, which I recognize that I skipped, you have to obtain consent when you're going to process sensitive data. And that includes when you make those inferences that we mentioned earlier. However, I think there are some useful exceptions to this consent rule. And a business doesn't need to obtain consent if it meets all of the following requirements. First, if you're processing sensitive data, but it's obvious to a reasonable consumer based on the context of the collection and use, then you don't need consent. If sensitive data inferences are permanently deleted within 24 hours of collection or of the completion of the processing activity, then you don't need consent. It's kind of a transitory data collection. Third, as long as any sensitive data inferences aren't transferred, sold, or shared with any processors, affiliates, or third parties, then you don't need consent. And then last, if the personal data alongside any sensitive data inferences are not processed for any purpose other than the express purposes disclosed to the consumer, then you don't need consent. All of which, I can see where Colorado and the regulators are coming from. It does start to create a lot of, the more exceptions that are built in, the more confusion there is. It's going to be interesting to see how that kind of rule, gets enforced. So finally, though, let's go ahead and wrap up with a discussion of data protection assessments. Now, everyone at this point has heard of a DPIA, right? A data protection impact assessment under GDPR. I will leave further discussion of that to our European colleagues. But in this case, we're starting to see that concept in the US. So, Eric, tell us about the DPA process. And yes, I fully share everyone's pain as to how many different acronyms there are. DPA now means data protection addendum, data protection agreement, or it could also mean processing. It means data protection authority. And now it also apparently means, at least in Colorado, data protection assessment. With that important public service announcement out of the way, please go ahead and let us know how the Colorado rules discuss what a DPA is and how you should do one.
So that we don't get this confused with maybe a data processing agreement, I'll just go ahead and call it an assessment. So the data protection assessment, Colorado requires that whenever a business is processing personal data in a way that produces a heightened risk of harm to the consumer. So at this point, businesses will have to document each of the processing activities that involve personal information. And this is a pretty laborious task. It's evidenced by how much of the regulations are dedicated to the assessments. It's part 8 of the regulations, and also section 6-1-1309. I welcome everyone to sort of look at them. It's very dense. It's about 5 pages dedicated on what needs to be included in the written assessments, including the level of detail, the depth, the scope, the analysis. And again, this is sort of a laundry list, and I don't know if we have time to go over all of them, but at minimum, you'll want to have a short summary of the processing activities, the categories of the data that's going to be processed, the nature and the operational elements of the processing activities. So what this means is that the assessment should include all the sources of the personal data, the technology that's being used to process, the names and the categories of the personal data that are being included in all of these processes, the safeguards that are used on the data, the core purpose for the processing activities, and details on the benefits of the processing that may flow directly or indirectly to the consumer, stakeholders, the business, and public. So this is a lot of information already that takes a long time, especially when there's a lot of stakeholders within a business that have a say on the information that's been flowing in and out of the business. And lastly, we have relevant internal actors and external parties contributing to the data protection assessment, and any internal or external audits conducted in relation to the assessments. You obviously need to date the assessment. You need to include who reviewed it and who approved it. So again, this is a very important part of the law that everyone should be aware of.
It's interesting, and being completely serious here, I do wonder how many of the folks who've drafted this type of rule have actually tried to do a data protection assessment. I think what we're going to end up seeing is an evolution of what all this means over time, likely via enforcement, and also potentially just amendments or modifications to the rules. All of those words make sense, but what I have experienced is it's one thing for the regulations to describe what should be in a DPA or an assessment, pardon me. It's another thing to actually try to do that in the real world. And that's going to be really interesting to see if we get, are there enforcement actions where the primary problem was an insufficient assessment? Or are we likely to see a situation where, okay, you've got something and that's better than nothing? Is that good enough? And we just don't know. So lots and lots of things to look forward to in the world of privacy regarding pretty much each new law that each state puts out. So Eric, thanks for being here today and sharing that information with us. But this wraps up this episode of the Gateway to Privacy podcast. We hope you enjoyed learning about the Colorado Privacy Act, its many regulations, including its data protection assessment requirement, and how we think that's going to go over the next few years. See you next time.
Thank you for listening to this episode of Gateway to Privacy. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks. That's HUB Talks in your favorite podcast app. Tune in next time for more data privacy insights.